Who's on this case? Mr. Haddad.
Yes.
State your appearance, sir.
Alan Rogers.
Good morning, Your Honor, and good morning to your staff. Ferris Haddad on behalf of Mr. Rogers.
All right. And are you looking to adjourn this or what are we doing?
Yes, Your Honor. I was retained this month, so we are still in the process of discovery. I'd like to adjourn the PCC and also address Mr. Rogers' bond after that.
Is this the only thing holding him?
Yes, Your Honor. I believe so.
Probable cause conference, January 8th, 2026, 9 a.m. As to bond.
Yes, thank you, Your Honor. So, Judge, I was retained this month, actually by Mr. Rogers' employer and Mr. Rogers himself, but with the help of his employer. He does have a job waiting for him as a finisher at A&M Auto in Ypsilanti. He's been working there for several years, and they're trying to hold the job open so that they don't need to replace him. He's a valued employee there. He's a hardworking gentleman. Judge, also, he's been incarcerated.
I don't mean to interrupt you, counsel. I'll let you finish, but I don't think this is the only case holding him. Because he was released on a furlough. And I think I signed off on the furlough here, but I think there was another judge in circuit that had to sign off on a furlough.
Your Honor, my review of that shell does indicate this is the only matter that's currently holding.
Is it? Okay.
Remanded by this court for bond violation.
Correct. But I thought somebody else had to sign off. Maybe I've got a different case. Go ahead, counsel.
Oh, no, I appreciate it, Judge. It's always good to get to the bottom of that. My understanding is he had missed some testing after initially being placed on bond and then eventually tested positive. But I think he's been incarcerated almost 50 days now. He does have a home. He has bills to pay. He has pets at his home. He has a job that's waiting for him. I'm not sure if they were waiting for a bed to put him into inpatient. I got that information from his former attorney. But what we did was we set up at a place called Serenity Therapy Center, where he can, if the court would allow him to get out, he can report to outpatient treatment and potentially intensive outpatient treatment there, so that he can actually get treatment. He's obviously
if you work out the treatment issue with the prosecutor, I'm not going to have a problem if he's released on a tether, but into treatment. But if I don't have treatment in place, I'm going to deny your motion to change his bond at this point in time, given the previous history on this case.
And Judge, can that be outpatient so he can get back to work and pay some bills and make sure that he doesn't lose his home and stuff like that?
Does the prosecutor have a position on that?
Not a professional in that area. I think the people's position is that Mr. Rogers needs to complete the treatment that's recommended by the professionals. There is an offer in place that he complete to a misdemeanor use. If he completes the treatment as recommended, that offer's been outstanding for at least a month.
Is that, counselor, are you aware if that's the treatment that's recommended for him? Is the outpatient?
I'm not aware if it's outpatient or inpatient that's been recommended, Your Honor.
Well, and his offer is contingent upon that, and he's going to have to complete the recommended treatment, and I don't know what status that's at this point. So what I'm going to do at this point, I'm going to adjourn it to the 8th. I'm going to deny your request for any change in his bond at this time. His bond will continue. If somebody gets me additional information, I'm more than willing to consider something else. But everybody's flying in the dark here at this point. So at this point, his bond will continue.
I understand, Judge. That makes sense. And are you saying that you would consider a stipulated order if the people and I work something out to that effect in the meantime?
Here's what I'm saying. Yes, I will consider that. But what I'm saying is part of his, as I'm understanding it now, his deal is that he has to complete the treatment that's recommended. I don't know what's been recommended at this point. And I would imagine that people would hold to that. If it's outpatient, then he's got to be out to do that. So I would imagine that everybody can come together and do a stipulated order. And I typically am not going to have an objection to it.
And if it's inpatient, does he have to wait?
This is
for-
really not that hard.
No,
But go ahead. What's your next question?
Yeah, it's just a question, Judge. If it's inpatient.
I
does he
know,
have
but
to-
I got like a billion people here and no, go ahead. What's your question?
No, I mean, if it's inpatient, is he awaiting a bed in community corrections? Because that's what that's sort of the idea that I got from prior counsel, is that he's waiting for a bed this whole time.
He might be,
Okay.
and our jail facilitates that. If he has a bed, then they'd let me know and we'd release it because I think there's already that order in place.
Okay. Thank you, Your Honor.
Is that it?
Yes.
Cool. Bond continued. Thank you.
Happy New Year. See ya.
Court calls case, People versus Anthony Alfaro Callejas.
I spelled this for people.
Attorney Zach Bonham on behalf of Mr. Alfaro Callejas, who's joining us by Zoom. Please unmute yourself and identify yourself for the record.
Anthony Alfaro Callejas.
Okay, very good. Thank you.
Yeah.
What are we doing?
Your Honor, we had an outstanding discovery issue that has been resolved as of yesterday evening. There was a video that was sent over from the prosecutor's office we couldn't access. My staff was able to get it visible yesterday. I need time to go over that with my client, and we have outstanding negotiating going on for a plea offer. So I would just ask this be reset for another PCC, and I would request for January 22nd.
No. Why are you requesting a date?
Because
Did
I
you
heard
talk to
January,
Joe Simon?
I heard January 15th being used quite a bit, and I have a conflict that morning. So I figured I'd get out in front of it.
Oh, he was getting out in front of it. That typically
Attempting to.
doesn't work.
Attempting
Yeah,
to.
that doesn't work. It was a nice try, though.
Did my best.
January 29th, will that work?
Yes, Your Honor, that'll work.
I knew it would. January 29th, 2026, without objection. 9 a.m. bond will continue.
Thank you, Your Honor. Happy New Year.
And to you, sir. Court calls the case, People versus Rivas Andrews.
Prosecuting attorney for the people.
Assistant Public Defender Ben Denwood, or Mr. Andrews, who is joining me at the podium now. Mr. Andrews, would you please state your name for the record?
Rivas Andrew.
Thank you.
And Your Honor, I believe Mr. Andrews would like to waive his exam. If that's true, sir, would you sign your name right there?
Is that a correct statement, sir?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah,
Okay, you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
that's right.
All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1, 2, 3 with 4 following.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for,
January 14th at 1:30 before Judge Conlon.
you said 14th.
Yeah.
January 14th, 2026, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Court calls the case of the People versus John Brooks.
Senator Water, assistant prosecuting attorney for the people.
Good morning, Your Honor. Michael Vincent on behalf of John Brooks. State your name for the judge.
John Austin Brooks Senior, yeah.
Thank you. What are we doing?
We are adjourning this. We have some discovery, some videos that I've informed will receive shortly.
He's Thompson. All right, I can go to the 29th, or if I could squeeze it on the 15th. Which one works?
29th, that's your honor.
Does it? Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continued.
Thank you. Stay in contact.
Court calls the case of the people versus Jeffrey Moore.
Good morning, Your Honor. Special Assistant Attorney General Mitchell Wood for the people.
And
This is House Defendant Nicholas Bukovich on behalf of Mr. Moore. Mr. Moore, can you please state your name for the record?
Jeffrey Edward Moore.
all right, thank you. All right, what are we doing?
Mr. Butkovich. Judge, Mr. Butkovich and I had a discussion this morning, and I'm stipulating to a slight reduction in his bond. His arrearage is actually lower now than it was when the AG issued the warrant. So I'm stipulating to a reduction to $5,375, Your Honor. That's 1/4 of his current arrearage, consistent with the statute.
All right, so 5275,
5375 is what I showed, Judge.
5375.
Yes.
Okay. And that's correct, counsel, you're stipulating to that.
Yes, Your Honor, we'll be stewing to that bond reduction. I was also going to still address bond when appropriate.
You want to address bond? I thought you guys did. Okay,
Okay, sorry.
go ahead.
So I do.
You request, what are we doing with the case?
We'll be waiving preliminary exam, Your Honor. I just provided Mr. Allen the waiver.
All right. Sir, is that correct?
Yes, Your Honor.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
All right. And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People do also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. S.J. arraignment, you waive formal reading, your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set
January 15th at 1:30 before Judge Slay.
January 15th, 2026, 1:30, Judge Slay. As to bond.
As to bond, Your Honor, I do appreciate the stipulation to modify bond to the lower amount based upon his current arrearage. I did want to address bond because my client, prior to this being charged out approximately 19 days, did make a substantial payment of $9,900, which could have been used for his bond if this could have been used for this bond at the later court date if he did not pay that amount. So I was wondering if there be any way possible that payment could be used towards his bond. I do understand that's probably unlikely.
What? He paid $9,000.
Yes, there was a payment on October 2nd toward the child support matter of $9,900 on October 2nd. This matter was charged out on October 21st, 19 days after after that payment was made. So one of the reasons my client does not currently have the had the bond
Paid
opposed.
$9,000. This case gets charged. His bond gets set at the amount of his, or 25% of his current arrearage. But then when they look at it, his current arrearage is actually lower because of the $9,000 payment.
Yes,
So you're asking me then to reduce it more because he made the $9,000 payment, but it seems to me that that's already been taken into account by the stipulated reduction.
yes, I understand, Your
Am
Honor.
I missing something?
I understood, Your Honor. I just wanted to.
Well, am I missing? I'm not missing anything. That's it, right?
Yes,
So it's already been taken into account. Motion for bond reduction denied. Bond will be set at the 5375 to be paid if that's cash, and it would be applied to the child support case. Yeah. All right, thank you.
thank you, Your Honor.
Thank you.
Thank you very much, Your Honor. Happy New Year to you.
Thank you, sir.